Good afternoon, this is Peter Towers from ESS BIZTOOLS. We're just about ready to start our webinar on Personal Property Securities Act. Thank you very much for your participation in this webinar today. There's quite a number of people registering and they're still doing so, so we'll give them another minute, which I think then will make it 12 noon, and we will get started. If during the webinar you have any questions you'd like to raise, and this is obviously a very widely discussed subject, Personal Property Securities Act, can you type your question in onto on your computer, and please then raise your hand in webinar jargon and send the question through to us, and I will try to answer it for you during the webinar. If you think of any questions later on, can you please send us an email and we'll do our best to get back to you. So thank you very much for participating in this webinar today. Obviously we're looking at the Personal Property Securities Act and the risks to your clients and what might be your PPSR action plan. Millions of dollars have already been lost by businesses both small and large, caused by ignorance of the Personal Property Securities Act and through not registering on the Personal Property Securities Register. I understand that legal action has been commenced against an accountant in a major city, claiming that no information on the PPSA had been distributed to the client. That was the client's claim. It will be interesting how that legal action unfolds. What's all this mean to accountants at this stage of the year in 2014? What does this all mean? And importantly, what role do accountants have in assisting their small medium enterprise clients to understand this Personal Property Securities Act? Some people have claimed that this legislation is the most far-reaching business legislation introduced into Australia in the last 200 years, virtually since the European settlements commenced. And the big issue, and the issue that a lot of people, including myself for a long time, and probably still do, is have this, understand this concept that title is no longer king. The biggest change that this legislation has introduced, in my opinion, is title is no longer king. The fact that a business paid for an asset does not mean that business is able to retrieve that asset at any time unless the business has taken steps to adequately protect their position on the Personal Property Securities Register. It's worth repeating. If the business has not taken steps to protect their position, even though they paid for it, they will probably miss out. There have been 6 court cases in Australia already on this legislation, which only completed its transitional phase in January of this year. And in each case, the business that paid for an asset missed out. The liquidator was able to claim a particular asset. So what is personal property? I think in the first instance, the government's made a significant mistake, and this was the previous government, not the current government, but they got the carry of this. The name is misleading. A lot of people think personal property covers their golf clubs, their clothing, their TV set at home. But it doesn't. Under this legislation, it is all forms of property other than real estate. And it obviously is business property. So how will the PPSR due diligence review assist you in reviewing your client's systems? The system includes a step-by-step procedure guide, videos, articles, checklists and forms to assist you to undertake a due diligence review. We believe it is necessary for accountants to be offering this type of services to their clients. Within our system, there are various articles on the way the Personal Property Securities Act and the Securities Register operates. There's a very detailed paper on the Personal Property Securities Register, some operational issues, and some advice on what you might need to do to talk to your clients. And within the system, we have articles to assist you to supply various information on this legislation to your clients. And we'll just have a look at a couple of those now. So I'll just go down and I will. First of all, there is a form which is the procedure control form to enable you to be able to monitor every aspect of what you're doing for a particular client under this legislation. There are procedures for the initial quotation and proposals. And there are various forms that you can then refer to and read with your client. So I'm just bringing one of them up now. The form you have on the screen now is the Personal Property Securities Frequently Asked Questions, which you could make this available to a client. You type the client's name in and the date, and it has a series of questions with the answers to be able to assist you with your client to get them a better understanding of how this legislation works. Some observers are claiming that less than 5% of small businesses have got a working knowledge of how this legislation is likely to affect their businesses. There's another form in the system on the 10 top myths within the PPSA. There's a lot of comments being made that aren't quite right, and we have commissioned a summary of some of these myths so that you could discuss this with your client, so that your client has a far better understanding of how this legislation is operational. There are also some videos which we are utilising that have been linked to the Personal Property Securities Register that have been produced by the government department responsible for this legislation. So where to start? That's the big question. There's no doubt that your clients require commercial legal advice on the retention of title clauses, and it's essential that these title clauses are drafted after the 31st of January 2012 so that they comply with this legislation. And your clients also will need a terms of trade agreement. But we believe that the drafting of the terms of trade agreement and the verification of the retention of title clauses is only the beginning. Unfortunately, many people believe that this is the end of the process, that you just get these two documents sorted out. Unfortunately, it is not. The Personal Property Securities Act is very complicated, and in our opinion, the responsibility will pass to someone else in the advisory chain advising small medium enterprises to ensure that an appropriate system is introduced for the small medium enterprise to protect their assets. And we believe that that professional group is the client's accountant. I've known and worked with hundreds of solicitors over my career. I can't think of virtually anyone in the legal area who would be prepared to go out and undertake a due diligence review of their clients' affairs to make sure that these systems have been adequately implemented to protect the client. And unfortunately, your client might not realise that they have not been compliant with the requirements of this register until many years in advance of today's date, because there is a need for a liquidation event to trigger this whole process. But in today's business world, no one knows when a customer or a business that you have leased or rented some assets to, or indeed you have left some assets with, or your clients have, when they might get into some sort of financial difficulties that enables a liquidator, trustee in bankruptcy, or receiver to be appointed. So that's the problem. Who's going to advise your clients on introducing an appropriate system? So the first question to ask in undertaking a due diligence review is, do your clients have a system? It's worth going back a bit in history and looking at what's happened on this legislation. When the GST was introduced, the Liberal government at that time spent millions of dollars, some people say about $100 million, in educating businesses, both large and small, on how the GST would operate. Unfortunately, neither the previous Labor government nor the current Liberal government have seen fit to finance a major education campaign for businesses, especially small businesses, on the operations of this legislation. There was little chance of a business going broke through the GST, but there's a real possibility that that could be the fate of a business for not complying with the requirements of the Personal Property Securities Act. And that is, in fact, they might not have gone broke at this stage, but that is in fact what has happened on the cases that have been decided. And marketplace rumour is saying that there are hundreds of other businesses that have already been affected but haven't ended up as legal cases. They've just had to grin and bear it and get on with their lives. Accountants are generally referred to as a trusted advisor for small business. In that respect, we believe that accountants have a responsibility to offer to your clients to undertake a due diligence review to advise them on the implementation of appropriate systems to ensure that the client has got some protection under this legislation if at some future date there is an unfortunate event where one of their major customers goes into liquidation, or someone that's holding assets owned by the business gets into the same sort of financial difficulties, because it's too late then to go to the register and try to register. There are very strict timetables for the registration of interests on this register. You can't do it in 3 years' time. So what transactions are caught under this legislation? It's worth having a look at so that you can get some idea. Some people believe the only time you have to worry about this act is when they sell their businesses to ensure any items which have been registered on the register have been withdrawn. And that's a bit of a feat in itself, as any of you who have acted for the sale of a business will probably know. But if only this were true. There's a lot more to it than just when someone goes to sell their business. There's a whole range of actions that need to be taken by most businesses to ensure the business is able to survive intact well before they consider selling their business, because there's a lot of potential problems on the road to running a successful business with this legislation. So we've got some of the transactions that are listed on these slides, and this is not all of the transactions by any word. Goods sold with retention of title. Remalpa clauses are still applicable as long as they're drafted appropriately after January 12. Supply of goods on consignment, goods in someone else's possession, goods attached to other goods. Now that's a change that's occurred on the previous legislation, so there are some benefits if your client is selling, say, some steel products that are sold to a client or another business who's then going to place them within their factory attached to something else. There are some protections under this legislation in that situation which really didn't exist in the past, relying on a Ramalpa clause. Mixed goods, where grains mixed with other suppliers' products in a silo, and where products from an ingredient supplier are supplied to a bakery, for argument's sake, and they're all then mixed up into making cakes or bread or whatever, there is some protection for suppliers of those products available under this legislation. One of the big areas that's causing some heartache is in the rental industry. Equipment renters have been caught out under the terms of rental agreements, and it needs some attention. Sorry, I went too far then. Motor vehicle leases, debtors. If you've assigned your debtors to a debtor factoring organisation, there's some issues. Livestock on adjustment is a perfect example of someone's assets being on someone else's property. If something happens to that property owner, as far as liquidation, etc. are concerned, there can be real problems. There are special conditions for motor vehicles, boats, aircraft, or any other type of asset like that that has serial numbers. There is some protection that's been built into this legislation for businesses that supply feed for livestock, that they can gain some protection under the legislation. It's worth looking at if you're acting for those type of businesses. And the same thing applies for seed, fertilizers, pest control for crops. Artwork and sculptures. I think we've got some New Zealand firms participating in this webinar, and they might have recalled that when this legislation started in New Zealand some years ago, there was considerable problems in the art world when a gallery went into liquidation in the main street of Auckland. A number of artists and sculptors, etc., rushed back in to try to take away the products that they'd left there on consignment, and were met by security guards that wouldn't let them remove the goods because they were goods supplied on consignment. They should have been, to have protection, they should have been registered on the register. And that's probably one of the problems here, because this registration on the register is voluntary. You don't have to do it. But if you don't do it, you obviously, that client will not have any protection under the legislation. So it's something that needs to be looked at very closely. But one of the key areas that is starting to cause some problems is things like loans, licenses, assets held on trust, service entity arrangements. There was a court case in Queensland whereby a company had supplied $2.3 million worth of Caterpillar tractors to another company within the group, and they'd entered into a lease or hire arrangement. The trading entity also obviously had debts, had a secured lender, and that company got into some financial difficulties. Apparently, when the liquidators were appointed, the asset owning company's representatives turned up and tried to take the tractors away, and they were prevented from doing this by the security people. And what had happened is the liquidator had gone to the register and done a search and found that no one had registered these tractors, so he had gone ahead and registered them. And the Supreme Court of Queensland upheld that action and said that basically the liquidator could deal with those assets which had been paid for by another business, virtually an in-house business that had not protected itself through a service entity arrangement by not registering. Intellectual property is another issue whereby intellectual property is developed by one entity within a group and it's then promoted or marketed by another entity. If a liquidator is appointed to that trading entity that's got the rights to distribute the intellectual property, your client could have some real difficulties under this legislation. Rental and lease of premises. Your client is undoubtedly placing assets, stock, plant and equipment, computers, etc., into someone else's premises. Sure, they've got a lease, but perhaps they need to be registering that transaction on the register to protect themselves in case something goes wrong with their landlord. It's worth thinking about when the government introduced this legislation, they obviously assumed that every business person would study the legislation and understand how it worked and would lodge the required registration to protect their interest. In theory, that works fine. However, in practice, the amalgamation of 60 acts from the Commonwealth, state and territories has caused a lot of confusion. I think the only winners out of this legislation at this stage have been the banks. It's caused a lot of confusion. This can only be overcome through a methodical approach to conducting an individual due diligence review for each client's affairs. Well, as far as we're concerned, that's the way we think it should be done. Someone's got to do it. Most clients won't be able to do this or have the time, and therefore we believe it's an accountant's role. So within our system, we have produced a detailed form to enable the evaluation of where are the assets situated, because this is one of the key questions to be answered if an insolvency event occurs. Where are the assets? And we've listed them there, and they go on for some couple of slides. I'll just go through that, then I'm going to bring that form up to show you of the types of assets. And you know, you can have assets that have been leased or rented, and it also brings in these other assets like debtors, financing, licensing, intellectual property, loans. Statutory fishing rights gets into the whole thing too somewhere on the line. Not probably a major issue for most of your clients. Assets held in trust, other personal property. So let's just have a look at what I've brought up now is Form 1645. We call it the personal property identification of where an asset is situated. And we think you really need to be able to identify where assets are. So we're first of all looking at stock. There's some different treatments of stock, but you're probably not worried if it's on your own premises, but it's when it's on lease premises, someone else's property, or out on consignment, that if you're undertaking a due diligence review, should be raising some concerns and saying to the client, well, where is it? What's the deal? What's it worth? What would happen if you were unable to get that property back? What would happen if, as what happened in the WOW stores in Queensland, they were a major chain operating in 5 or 6 cities in Queensland, and they got into financial difficulties. The liquidator was appointed, went in, and what I can ascertain, only a couple of the suppliers had registered their interest, and the market rumour is about $26 million was lost by suppliers to those stores because they had property on consignment and sitting in someone else's premises that hadn't been paid for, and they were unable to claim the ownership of that property. How would you feel like fronting up to one of your clients that ended up in that same position? And the sobering thing about that little case is I suspect most of those suppliers would have been from the big end of town rather than small, medium enterprises. So the questionnaire takes you through to undertake a methodical review of everything that might affect this particular client. Do they have an up-to-date terms of trade agreement? And one of the catches in these terms of trade agreement is that if there's a change in the type of relationship that your client's got with a customer, then it might mean a new agreement has to be drafted. For argument's sake, someone's supplying coffee beans to a cafe as a supplier of stock, and if their terms of trade agreement only refers to that type of transaction, if they then decide to lease or rent or even give for a while a coffee making machine, that action would not be covered by the terms of trade agreement unless it was drawn wide enough to cover those types of situations. And they might have to lodge a second terms of trade agreement. So this requires a fairly consistent and constant review going on as to what's happening within the client's business. Then we've got livestock and crops. I've mentioned thoroughbred horses. When we were designing this, my assistant said, what do you put thoroughbred horses in there for? Well, I've done it for a very particular reason. There's been a major court case in New Zealand where a stallion was leased to a breeding farm where it was at stud, and lease payments were being paid. The company owning the farm got into some financial difficulties. The horse was repossessed by the owners because they hadn't been getting their payments, but a liquidator got appointed by the secured creditor. The liquidator sought the court's approval for him to repossess the horse, which the New Zealand High Court subsequently approved, and approved that the liquidator could proceed to sell the horse. Some reports have indicated that the horse was worth $2 million, the stallion, and it was forfeited to the secured creditors. I don't think the owner of that horse would have been very happy, and probably had a few words to say to whoever had been advising them on what they were doing. Perhaps they hadn't got any advice, but that's one of the reasons we've left horses there, thoroughbred horses. And I noticed the Victorian Racing Authority has released a specific paper on thoroughbred horses, which is based on the New Zealand court case. Crops are another area. So this form, which is part of our system, goes on to look at all sorts of transactions that could affect assets owned by a business. Brings in artists' works, paintings, sculptures, etc., so that you can get a far better idea of where things are. So the system that's been developed within ESS BIZTOOLS includes a customized system for individual clients. There's a procedure control form for each of your clients to enable a systematic review to be undertaken. There's procedures which require you to review the retention of title agreement and terms of trade agreement in particular, to check whether the client has had commercial legal advice since January 2012, and probably preferably now since January 2014. I think there's a need to look at the exposure risk of individual customers, and they're those forms that I've just showed you. And one of the big problems is renting, leasing or storing assets on someone else's property, that your clients need to be aware of the problems if they want to have protection. The system also requires the acceptance and signing of trade agreements, secured party group registration. That's part of the process with the PPSR to speed up the registration. How you go about preparing financing statements and the time period that they must be prepared in, and the preparation of purchase money securities interest. Now, the purchase money securities interest is a very important document that the suppliers of stock to a customer, so to a retailer that they're going to use it as inventory, can gain protection on, and selling of goods on consignment, and selling of goods that have got a remalpa type clause, retention of title clause, can all gain a super protection, which is the PMSI, Purchase Money Security Interest. But the application through the financing statement must be lodged within specific time periods for the supply of inventory before you supply the goods. So our recommendation is your clients should be looking at this situation from the time they decide to open an account for a new customer and deciding there and then whether they're going to register this customer because they're going to be supplying stock to them, and that they then proceed to do so. If you supply goods, so you sell a machine to someone who's then going to use it in their business, and you wish to protect that transaction, you've got 15 days to register on the register to get a PMSI. And if it's a document like a loan document or a intellectual property type agreement, you have 20 days. But that's all the time period that your client has got if you are going to get a super protection. So there's needs to be monitoring timetables relative to this whole process to gain adequate protection. And there's some of the other notes there that we've talked about, some of the specific follow-ups that need to be done. We've developed individual due diligence forms to assist businesses in 15 individual industries. And I'm going to bring one of these up now, but there's a summary: retail, renting, leasing. These are all industries that have got some peculiar requirements that creep into them. I'm having trouble. This is the form for the wholesaler supplier. We have a summary there, first of all, of the ways that a wholesaler could have a problem under this legislation. And then we have procedures for you to go through, answer some questionnaires, and make the recommendations to the client as to the type of system that they should be implementing to protect themselves under this legislation. So I've just gone back to the main procedure control form now, and we've moved on a bit from where we were before. So we've got the assignment, and this form helps you work through the various work lists. I showed you those before, whereby you've got individual questionnaires on stock, livestock, artist works, plant, equipment, etc. Service entities. The material to assist you to do the due diligence reviews on your clients' systems. Have they got retention of title? Have they got terms of trade agreement? Has the business considered their exposure to individual customers? And this is the big issue. I know some people think you have to register every invoice. You don't. You're basically registering a customer. And it's a good idea to consider what your exposure to that customer might be. So we've drafted some forms which will assist you to discuss with your client what sort of exposure that they might allow within their business before a decision is made to register that particular customer on the register. So what we have on the screen there now is some due diligence review to go through on customer due diligence. And what we're suggesting there that your client should be establishing a total exposure. And that might be for some businesses $100,000. So if the estimated trade of a particular customer over, say, 90 days, so you allow a bit of period if they haven't paid you, has got to $100,000, would that financially embarrass the client? If it would, then we'd be recommending that you should be registering the transaction, the customer, on the register. But for some businesses, embarrassment might be at $5,000 or $10,000. And the other thing you need to think about is, unfortunately, bad luck seems to come in a number of other businesses at the same time, especially if your client are supplying primarily particular industry groups, and there might be some problems within that industry group. So the individual exposure and total exposure might have to be looked at to be on the basis of what happens if there were 3 or 4 of these happen virtually at the same time. What would that then do to this business? So there's forms there to assist you to make that decision. This is just giving you some idea of the main procedure control forms. There's a lot of other forms and papers, obviously, in this overall system. But we'll just move on. So we have developed individual forms for all those types of industries that are listed on the screen. We conducted a webinar like this a week or so ago with David Smith from Smith Inc. And one of the participants was an insolvency practitioner, and he came through and made a comment during the webinar, and I asked him if he was prepared to give a testimonial, and he has. He believes that quite often insolvency practitioners are faced with suppliers who have retention of title clauses in place but are not aware of the changes that took place in January 2012. I'm told by insolvency practitioners this is very common. This lack of awareness amazes me, says Darren Vardy, and is predominant amongst small business. Unfortunately, the business owner generally finds out the hard way when faced with an insolvency practitioner who tells them that they no longer have title and or ownership of goods. This is certainly an opportunity for all accountants to add further value to the relationship with their clients by conducting a PPSR review to ensure their compliance. And that was submitted by Darren Vardy from SV Partners in Sydney. So that's what a liquidator thinks. When I said before that the banks were probably the real beneficiaries of this legislation, I suspect the liquidating profession's done fairly good out of it as well, in that there's been assets there that traditionally they would not have been able to access. So this product, which covers all of the forms and papers and links to some videos that we've discussed today, together with any further updates that are produced over the next 12 months, we will be advising you when they're available, is part of a package which is for sale at $350 plus GST, so that's the $385 for 12 months access to the product. You are able to download this, and we will be sending you updates as we develop them on any changes and particular news events. And we're going to try to monitor events concerning accountants and solicitors under this legislation, especially if disgruntled clients are taking action against people. So you can go onto our website, www.essbiztools.com.au, and follow the process to register if you would like a copy of this system sent to you. If you are a gold or silver subscriber, or you wish to become one within ESS BIZTOOLS, then you get free access to this product because it's part of the services which we're continually developing for our subscribers. I'm just going to check whether there are any questions. There's no questions coming up on the screen. If you have any questions later on that you think about, that you'd like to have answers for, can you please send me an email, peter@essbiztools.com.au, and I'll reply to you. We have recorded this webinar, so it will be available tomorrow, and we will be sending you an email to and someone's just asking me exactly that same thing, I think. Yes, we'll be sending you the webinar recordings and these PowerPoint slides tomorrow, and that will be, the PowerPoint slides will get sent direct to you, and you'll be able to download the recording from YouTube, and we will give you the links. Someone's asked me, do you have instructions on how to actually register property? We discuss it, but we, at this stage in this process, we've been more concerned with making sure that small, medium enterprises have adequate systems in place to decide whether they should register. There's a number of fairly good videos on the PPSR site now to guide you through the registration process. If you run into any particular issues, I'd be happy to assist, because we do have a network now of people who are very interested in this legislation, who also have had extensive experience in all sorts of businesses being registered on it, so we can give you some updates on that. Someone said to me, the longest 10 minutes ever, but the best 10 minutes ever as well. I don't think we publicised this as being one of our 10-minute webinars. If we did, I'm very sorry. We have been running 10-minute webinars, but this one was not meant to be a 10-minute one. We budgeted for 45 minutes, and we're just about there. So thanks, Dale, for your comments. Is there any other questions or comments anyone would like to make? Please, if you get anything out of this webinar today, sit down and have a serious look about how you are going to discuss this issue with your clients. David Smith from Smith Inc., who many of you will know, made a comment to me a couple of weeks ago when I discussed all this with him in Sydney. How would you feel as an accountant if one of your clients really got caught up in something like this? And when you look at some of the court cases which were summarised in our paper, which is part of the package that you would be getting if you subscribe, there's been some fairly horrendous losses, and in some cases the liquidators were appointed by the secured creditor, who turned out to be also the lender to the business that had purchased an asset. And the secured creditor, through the liquidator, has sold off the asset and taken whatever proceeds they could get for that. And I'm told that they are now taking action against the business that originally acquired the asset, because they've got a debt owing back to the bank on that asset which they've no longer got. I have great difficulty getting my head around that, but that's the world we're now living in. And I think we, as professional advisors, we all need to think very carefully about what we're doing with our clients. Now, someone else has sent a question in or a comment. This relates to builders and their tools as well, if left on site, presumably. Yes, it's well covered in our papers and our materials. I might have missed it in the slides. It's been an issue that's caused some eruptions in various sites. I know one in Queensland where there was a fight between the contractor who owned the equipment that was behind a fence. There were security guards there, and I'm told some of the security guards were off-duty policemen, and it caused a bit of a problem. The contractor was actually arrested at the time. So some of these things can get out of hand a bit, and they're not going to disappear. These issues are going to continue to arise for your clients, and the real problem with this, there's a real sleeper type situation. Some of your clients hopefully will never face up to a problem under this legislation, but for others the problem might not occur until 2, 3, 4, 5 years time, when they're merrily going along their way and suddenly they find they've got a major problem with a customer who hasn't paid them and they've got no registration protection, or what tends to have been the bigger issues on the court cases decided in Australia so far, they have placed assets in someone else's premises that can cause a problem. So thank you very much for participating in this webinar today. Don't forget, if you have any further questions, please send them through to us. Have a wonderful time today. Goodbye. Thank you.